So the next speaker has been a speaker here in Alaska multiple times under the umbrella of cervical cancer prevention. Today, however, we're welcoming Dr. Rachel Masch to talk about a different topic. Dr. Masch is the clinical professor at the Icahn School of Medicine at Mount Sinai in New York City. And she's also the chief medical officer of Basic Health International. She wears multiple hats. She's a very dear friend, and I greatly appreciate her tackling this extremely challenging but important topic on which she's going to speak next. And that is the impact of the Roe v. Wade upheaval on gynecologic cancer care. No matter where you stand on the issue of abortion, a change of this magnitude nationally has impacts on all of us as doctors and all of us as patients and all of us as people who face difficult challenges and difficult questions in our healthcare. So not to shy away from a tough topic, I asked Dr. Masch to take it on, and let's see what she has to say.
My name is Dr. Rachel Masch, and I'm going to speak to you today about the effect of the Dobbs decision on cancer care and pregnancy. My objectives are to give you a brief overview of cancer and pregnancy, and then review the Dobbs versus Jackson Women's Health Supreme Court decision and talk about the implications, give examples from different states, since now it is up to the state to decide if a woman can get an abortion, and then do a short case study. Lastly, I'm going to talk a little bit about what's next. Here are my disclosures. I am a speaker for Organon, and I'm also the Chief Medical Officer of Basic Health International. So let's review cancer in pregnancy. Cancer is the second most common cause of death in the reproductive years. Accidents are number one. The incidence of cancer in pregnancy is not common, about 1 to 2 in 1,000 pregnancies, and there's been a slight increase because of the advanced age of some people at the time of pregnancy. The most common malignancies in pregnant women are breast, and then the list is here on the left-hand side: lymphoma, leukemia, cervical cancer, ovarian cancer, and then thyroid cancer. Cancer diagnosis can be tricky during pregnancy because pregnancy comes with lots of physiologic changes. Plasma volume increases, there's a redistribution of fat, the breasts change, many other things as well. Also during pregnancy, radiation exposure, which is a common treatment for cancer, really depends on when in pregnancy the cancer is diagnosed and when the radiation is given. Also, what organ needs radiation therapy and how far that organ is from the growing fetus. There's also the medications and the chemotherapy that can be teratogenicity, that can have teratogenicity, and that differs also depending on when in pregnancy it is given. The outcomes of pregnancy in women with cancer is most likely prematurity. That's the most common adverse outcome that's reported. And preterm birth is more common because of usually a medical induction because of the woman's cancer needs. Also with prematurity, but also just alone, there's small for gestational age neonates, and that is more common after people have cancer in pregnancy. And there are possible long-term complications such as neurodevelopmental or cognitive impairment, heart problems, ear or hearing issues, endocrine problems, and then an increased lifetime cancer risk. Here is an image of the growing fetus. The number of weeks is listed on the top and when different organs develop. So you can see here that when radiation therapy or chemotherapy needs to be given, these are when different organs are developing. And these are things that one needs to be aware of. So let's turn our attention to the Dobbs decision. That decision came down on June 24th of 2022. It is Dobbs versus the Jackson Women's Health Organization. And Jackson Women's Health was the only remaining abortion clinic in the state of Mississippi. The case was brought to the court by the Center for Reproductive Rights and its partners on behalf of Jackson Women's Health Organization. It challenged the Mississippi ban on abortion. Mississippi appealed to the Supreme Court after the Fifth Circuit Court of Appeals upheld a federal district court ruling that granted a permanent injunction against the ban, meaning allowed for abortions. The Dobbs ruling upheld the Mississippi state ban and abandoned the constitutional right to an abortion. So the decision, therefore, allowed Mississippi's ban to take effect, and abortion access and regulation was no longer a constitutional right, but now it was up to each state to decide if and when they were going to provide abortions. So what does it mean? What does it mean for patients? What does it mean for providers? So here's a case study. AJ, 28-year-old, she'd been pregnant 5 times, had 4 children at home. She was 18 weeks pregnant and in Mississippi. She was diagnosed with aggressive stage 3 recurrent estrogen and progesterone receptor positive breast cancer. She was told that because of the hormonal status of her cancer, pregnancy could accelerate her disease. And the specific chemotherapy she needed was not advised during pregnancy. However, Mississippi has banned abortions with very few exceptions. So she needed to decide whether to take the risk of having her disease progress over the next 22 weeks, or if she was going to travel out of state to obtain an abortion. So this is from the New York Times as of January 6th, where abortions are banned. You can see that 13 states now fully ban abortion, and one state, Georgia, has a 6-week ban in effect. The current abortion landscape, this is from Guttmacher, shows the most restrictive states, which are the ones where it is banned, that's in dark red, to the most protective, which is Oregon. And the blues are more protective and the reds are most restrictive. So there are some legal exceptions. So if the maternal life is endangered in 12 states, then that is an exception. However, the wording is very vague, and it can put a physician or another provider at substantial risk by giving them large fines, making them go to jail, or lose their medical license if they provide an abortion that is not deemed to meet the narrow allowable circumstances. And procedures get delayed until a patient has a dire medical emergency, which is always harder to take care of. There's also some exceptions for severe physical health conditions. That's in 7 states. So if a patient has one of these conditions, which is not clearly defined, but it is not in an emergency situation, their care could be denied or delayed until the condition worsens. And then in 3 states, there's an exception for rape, and in 2 states, there's an exception for incest. But in those states, the crime has to be reported to legal authorities. And we know that a majority of rape and incest survivors do not report the crime. Also, laws that do not require a police report can place providers in the position of having to prove that the assault actually meets the requirements of this exception. So there are exceptions, but they are difficult to uphold, and the wording is vague and can put providers at risk of loss of a medical license, fines, large fines, or even imprisonment. There are, however, legal challenges, and here are some examples. So as of January 10th, the Idaho Supreme Court upheld 3 state laws on abortion, stating that the state constitution contains no right to an abortion. So it this law bans abortion just at conception at 6 weeks, and this is a civil enforcement. South Carolina, however, their Supreme Court said that the ban on abortion after 6 weeks of pregnancy was unconstitutional, and it put unreasonable restriction on a woman's right to privacy. So those are 2 examples that are on either side of the spectrum. And then Ohio had really what I have called a legal seesaw. So after the Dobbs decision came down in June of 22, the Ohio legislature convened a special session and enforced the fetal heartbeat bill, meaning that it banned abortions when a heartbeat is detected on ultrasound, which is about 5 to 6 weeks of pregnancy from the last menstrual period. So providers could only legally provide abortions at less than 6 weeks. But then in September, a judge granted a 14-day restraining order against that state law, which paused all of those restrictions. And then about a month later, 5 weeks later, a judge granted a motion for a preliminary injunction against the abortion bans, and abortions through 22 weeks could continue in keeping with the state law that was in place before the ban. Ohio residents now are waiting for any further legal action that could again limit abortion availability. There's also medication abortion. Medication abortion involves taking 2 different pills, mifepristone followed by misoprostol. It is FDA approved to 10 weeks of pregnancy. And in December of 2021, the FDA permanently lifted the requirement that patients obtain mifepristone in person from a health provider. So that allowed for telemedicine services and pills by mail. Mifepristone, or the abortion pill, is now allowed actually to be dispensed in retail pharmacies as of this month. And those details are still being worked out. So access is limited, however, in those states where abortion is not legal. There are ways of getting around that, however, and an organization called Aid Access, which started in 2018, actually ships the pills from abroad, from other countries outside of the United States. And there is really limited action that is possible against Aid Access because this is a non-US based company. So there are some measures where people are trying to fight back. So in terms of access, the estimated time to travel to get to an abortion facility in the United States has significantly increased. Before the Dobbs decision, a little less than 15% of people lived more than an hour from an abortion facility. And after the Dobbs decision, that number more than doubled in terms of people living in more than an hour from an abortion facility. And we know that when people live more than 50 miles from a facility that provides reproductive health services, they're more likely to still be seeking an abortion after 4 weeks than those who live closer. That intuitively just makes some sense. And then things that maybe people don't think about for people who have to travel outside of their state or outside of even their region to obtain an abortion. It's like, how are they going to get there? Where will they stay once they do get there? How will they have money to get food? What about childcare for their children who are at home? They have to miss work. What if they have a complication during the procedure or postoperatively? And if they do have a complication and they're already at home, will they be able to get care? And what will be the legal ramifications of that care? So let me just go over a few different places to give you some examples of what if a pregnant patient with cancer who needs an abortion lives in one of these 4 states, Alaska, Georgia, Florida, and Mississippi. And abortion laws, you'll see, can be vastly different depending on the state. So let's start with Alaska. So abortion remains legal in Alaska. Only physicians can provide it, so no nurse practitioners or physician's assistants. It is not restricted based on gestational age, and state Medicaid funds do cover the procedure. In 1997, the state's highest court recognized that there was a fundamental right to reproductive choice under the Alaska Constitution. But as of June of last year, just a few days after the Dobbs decision, Alaska also said that a patient must receive state-directed counseling that includes information designed to discourage the patient from having an abortion. So that's Alaska. In Florida, abortion is banned at 15 weeks and later. The patient must make 2 trips, one for an in-person counseling session, and then another at least 24 hours later for the actual procedure. Medicaid does not cover abortion, except in very limited circumstances, and parental consent is required if a minor wants to get an abortion. Only physicians can provide abortions, so no other qualified health professionals can. There are some exceptions to the Florida law, extremely limited exceptions, but an abortion after 15 weeks from the last menstrual period can be performed if that abortion is to save the pregnant woman's life or avert a serious risk of substantial and irreversible physical impairment of a major bodily function of the pregnant woman other than a psychological condition. And the second exception is that 2 physicians need to certify that this conclusion, that in their reasonable medical judgment, that this is a viable exception, or if there aren't 2 physicians available, a single physician has to certify that the risks are imminent and that another physician is not available for consultation. In Georgia, abortion is banned at 6 weeks and later. Patients need to wait 24 hours after a counseling appointment to get an abortion. And Medicaid does not cover abortion services except in very limited circumstances in Georgia. There's parental consent for minors required, and again, only physicians can provide abortions. Some exceptions to the 6-week ban in Georgia. There are 3 very narrow exceptions. One, if there's a medical emergency, which shows that the woman has that there's a risk of substantial and irreversible physical impairment of a major bodily function, but it does not permit an abortion if it is substantial but reversible physical impairment, if it is less than substantial but irreversible physical impairment, or if it's to a bodily function that is not, quote, major. But these are not well defined. And so the amorphous quality of these exceptions make it difficult for providers to decide if it fits into one of these categories. It also prohibits a physician from providing an abortion based on a, quote, diagnosis or claim of a mental or emotional condition, or that the pregnant woman will purposefully engage in suicide, self-harm, or dangerous behavior. So those are not exceptions that are accepted in Georgia. Also in Georgia, there's an exception for rape or incest, but only if there is an official police report. And as I mentioned earlier, many times these crimes go unreported. And the last exception is if it is a, quote, medically futile pregnancy, but again, that is not well defined. Lastly, one of the last examples I'm going to give is Mississippi, which is where our case report, AJ, is from. Abortion is now completely banned with very limited exceptions in Mississippi. If a patient actually has one of those exceptions, they are forced to make 2 trips, one for the counseling session, and then at least 24 hours later for the actual procedure. Medicaid does not cover any of these abortions except in very limited circumstances. Medication abortion must be provided in person because the state bans the use of telehealth or mailing pills, and those are only if it fits into one of the limited exceptions. The parental consent or notice is required for a minor's abortion, and again, only physicians can provide these procedures. So here are some of the Mississippi law exceptions that there's an exception: an abortion can be performed when it is necessary for the preservation of the mother's life, or where the pregnancy was caused by rape and a formal charge of rape has been filed with the law enforcement. In Mississippi, there are criminal sanctions on any person except for the person who's pregnant, who purposefully, knowingly, or recklessly performs or attempts to perform or induce an abortion. And that means that if they get accused and convicted, they could be imprisoned for not less than 1 year and no more than 10 years. There are some states that have protections. So 16 states have codified abortion in their constitutions, and those are listed here. And then there are other states that are working to make abortion a constitutional right: New York, California, and Vermont, because courts can invalidate a state law, but not a constitutional amendment, because they are actually bound by that document. There are other actions that are being taken, such as the bubble zones, which limits protests near doors of medical establishments that are providing abortions. People are trying to have require insurance companies to cover abortions. There are prohibitions for state agencies to assist out-of-state investigations. And all of these have legal ramifications and can be tricky in terms of interstate commerce laws. And it's all still, it's a brand new world, and we need to try and fight back as we can. But we need to do it in a legal framework that is viable across states. So what happened to patient AJ, the patient who was 18 weeks pregnant with recurrent stage 3 breast cancer that was estrogen and progesterone receptor positive? Well, she was connected with a funding organization, and she actually came to New York City, where I am, and she was able to have her cervix dilated and then have an abortion procedure at Mount Sinai. Her case was uncomplicated, and she flew back to Mississippi to start her cancer treatment 2 days later. So what are the conclusions? Well, we know pregnant people can get cancer, and the Dobbs decision has rescinded people's bodily autonomy. That effectively erodes the provider-patient relationship and limits the healthcare options that a provider may deem that is best for a patient's health. It also disproportionately affects people who face systemic barriers to care, communities of color, people with low incomes, undocumented immigrants, young people and minors, the LGBTQ+ community, and people with disabilities. It also has ramifications for people's education, their careers, their economic, in this case, insecurity, their earning potential, and their mental health. So what can we do? Well, first and foremost, vote. Engage with your members of Congress. There's a way of finding, if you don't know who your congressional representatives are, there's a way of finding who your Congress people are. Also, speak out once you find out who they are. Write to your local and your national political representatives. Let your voice be heard. Volunteer at one of these following organizations: the National Abortion Federation, National Organization of Women, NARAL, Planned Parenthood. There's also the National Network of Abortion Funds, which helps patients such as AJ get funding to get the care that they need. And the website is there. It's actblue.com. There's also If, When, How, which is a legal reproductive defense fund, and the website is listed there. But most importantly, I think we need to listen to, believe, and support pregnant people. I'm happy to take any questions. Thank you for your attention.